Good afternoon. Welcome to Student Loan Relief. This is Laura Beckman. I'm with the Public Interest Law section of the Florida Bar, and in conjunction with Legal Services of North Florida, we are proud to present you with this webinar today on student loans. Just so everyone knows, in your GoToMeeting panel under handouts are the PowerPoint that we're going to be using today, as well as the approval for the CLE today. We are very pleased to have Joshua Cohen with us today, who is known as the student loan lawyer. So I think he is the definitive expert on all things student loan laws. Josh comes to us, he's got his undergraduate degrees from Brandeis University in psychology. He's also got an MBA from the University of Phoenix and his JD from the Quinnipiac University in 2007. He's a member of the bar in both Connecticut and Vermont, and has found his way into student loan law through some work that he did with Connecticut Legal Services while he was still in law school, and has since worked at the Consumer Law Group and now has his own practice where he specializes in consumer protection issues and particular student loan issues. So Josh, thank you very much for your time today, and we look forward to hearing from you.
Thank you for having me. So I've got an hour to present lots of student loan stuff. So what I'll say is, as questions come up, I'm welcome to take them. If they're not relevant to exactly what I'm on, I'll push them to the end. But this is kind of foundational. It's a little bit like building a spider web. So if you're not sure of what I'm talking about at that moment, feel free to ask questions. With that, I will tell you. Our topics will include the types of student loans, federal versus private loans, which is key. And the remainder of this is really going to be on federal student loans, including the entities involved, the types of federal loans, administrative discharge, which is getting rid of a loan by filling out paperwork, not requiring bankruptcy. We'll talk about repayment plans so that people can manage their loans, which is really the secret and what most people need. Talk about the forgiveness that's out there, default and the consequences and the cures, and of course default consequences are why many of us have clients. And then we talk about deferments and forbearances, what those really are, and talk a little bit about some bankruptcy options that are out there. So with that, we'll dive right into the types of loans and all of these entities that we deal with. We start with what makes a loan a federal student loan. And basically, it's a loan that is either guaranteed by the U.S. Department of Education, or it could actually be originated by the Department of Education. You'll see a technical slide coming up in a minute. As opposed to a private loan, it means there's no federal entanglement whatsoever. It's originated by a private bank. It's not guaranteed by the Department of Education at all. And it has pretty much the same consumer rights and protections as any other consumer product. The only exception is bankruptcy discharge because of 523A8B, which I'll talk a little bit about when we get to that at the end. Then we have state loans. They're offered by state agencies. They're available to state residents or non-residents attending a school within the state. Last I knew, Florida doesn't do this, but I'll leave that to you folks to double check. They are more popular up here in the north. New Jersey has them. Connecticut has them. Vermont has them. New Jersey made New York Times a year or two ago for offering New Jersey higher education state loans. They're collected by New Jersey, and they tend to be a problem because of the remedies. You'll find federal loans are very flexible because if you default, you can get it out of default. State loans really don't have that. So once you're in default forever, and they still have administrative remedies that don't expire. And that's what makes state loans very difficult. Often they also have a cosigner involved. Federal student loans rarely have a cosigner involved. So I just find state loans are the most difficult to deal with. Okay, so moving forward, private student loans, again, they're not guaranteed by the U.S. Department of Education. Many of them are insured, however. There are few, if any, payment options. Usually it's pay or don't pay. That's always a fun option for your client. Enforcement's the same as any other consumer debt. They've got to be sued before anything can happen. Bankruptcy discharge, only with the Brunner test, which you folks have down there. The Eighth Circuit uses totality of circumstances. The First Circuit hasn't established a test yet. There are some exceptions discussed in the bankruptcy section. But again, when we talk about the remedy, again, with the private loan, if they never sue your client, they can't force any money out of them. And the post-judgment remedies are based on your state law. The statute of limitation is based on Florida state law. And I love Florida because I know you guys will borrow the statute of limitation based on the promissory note. So if you have a promissory note that says Delaware or New Hampshire or North Carolina is the controlling state, the statute of limitation is only 3 years. And I know Florida will borrow that. And I know that Florida caps the statute at 5 years based on Florida law. So that's a nice little thing you can use if you defend any of these private student loans. Always look at a statute of limitation defense. All right, so now let's get into federal student loans. We start with the history, very simple. It started with the GI Bill, which pays for 48 months of education. And after 48 months of education, you should be getting a bachelor's. There's a joke that I won't say here, but it's becoming harder to get a bachelor's within 48 months, but it was originally meant to be within 48 months, 4 years. Then Perkins' predecessor came along. In 1965, the Higher Education Act came out and it created the FFEL market, which I'll talk about in a second. It's really a secondary market. The loans weren't originated by the Department of Education. They were originated by banks but guaranteed by the Department of Education. In 1993, the Student Loan Reform Act came along, and that created the Federal Direct Loan Program. For any of you that do bankruptcy and have read losing adversary proceedings where people attempt to discharge, you will often see that the debtor loses because they failed to apply for the Federal Direct Loan Program, the William D. Ford Federal Direct Loan Program, which can give them friendlier payment plans. That is changing a little bit. And then in 2010, the Healthcare and Education Reconciliation Act actually terminated the FFEL market that was created in 1965. So as of July 2010, the only game in town is the Federal Direct Loan Program, which means loans are coming directly from the Department of Education. All of this is controlled by the Higher Education Act, which can be found at 20 U.S.C. at Section 1001, etc. And there's only a small section that really relates to student loans. So don't be overwhelmed by it. If you can do the tax code, you can do student loan code. All right. So let's look at the parties. This is when people come into your office and saying their loan's been sold 17,000 times, and you can go through it and realize, no, it hasn't. Federal loans are never sold. We start with the U.S. Department of Education. They oversee the industry, they lend money, and they insure loans that were originated by others, such as a guarantee agency or a bank. They do a lot of other things, but for our purposes, these are the three things that they work on. Then we have guarantors or guarantee agencies, which are nothing more than insurance companies. They lent money prior to July 1st, 2010 under the FFEL program. They insure loans that were originated by private banks, again, under the FFEL program. Right now, the only thing they're left to do is to service loans held by the Department of Education, and some examples are ECMC, which is Education Credit Management Corporation. If any of you do bankruptcy work, I'm sure you've heard of ECMC. MOHELA is Missouri's guarantee agency, Missouri Higher Education Loan Authority. Great Lakes is another example of a guarantee agency. VSAC out of Vermont, Granite State out of New Hampshire, Cornerstone out of Utah. These are some examples of guarantee agencies. So they still have their original business from before 2010 of insuring loans, but after 2010, they had no new business, and many of them got out of the market. Some of them stayed, and now they are services for the Department of Education. Another big one out there is Texas Guarantee, which has since changed its name to Trellis. And Great Lakes has actually changed its name to Ascendium. There's a lot of name changing going on out there. If you have any questions after this, you're welcome to email me with that as well. Private banks, what do? You can snicker here. For our purposes, they lent money prior to July 1st, 2010. The examples were Sallie Mae. Sallie Mae is now known as Navient. It's the same company. Wells Fargo, Citizens, SunTrust, you name a bank, they were in the student loan industry. Citibank used to be, Discover still is. So they were involved before July 1st, 2010. After, again, July 1st, 2010, only Department of Education. So if you see a private bank or a private loan, if you see a loan that was originated by a private bank after July 2010, it has to be a private loan. Then we have servicers. Much like the mortgage industry, they don't hold the note. Their job is to send statements and accept payments and maybe take phone calls. They only work on loans that are in good standing or delinquent, and delinquency is a term of art for federal student loans. It is when you're past due but not yet defaulted, and I'll get into that in a second. And then we have debt collectors. They contact borrowers to secure a payment, but they only work on loans that are in default. No servicer is a debt collector. No debt collector is a servicer, with one exception. Navient seems to be doing both sides. They service loans, they originate loans under private student loans, and they're also debt collectors for usually United Student Aid funds, which is a guarantee agency. Other than that, no servicer is a debt collector. So if you've done any debt collection defense work or bankruptcy, and you've heard of these companies such as National Enterprise or blanking on all of them now, GC Services, Allied Interstate, those are debt collectors. And if your client comes in and says, I'm getting a call from Allied or one of those guys, they are in default. They are not in good standing. Your client might think they're in good standing. That also means they're in denial. But the bottom line is, debt collector, the loan is in default. It's a servicer, the loan is in good standing or it's in delinquency status. For those of you that do FDCPA work, it's got to be with a debt collector before the FDCPA kicks in. Only defaulted loans fall under the FDCPA. Delinquent loans do not. And yes, the FDCPA does apply to federal student loans. I can tell you that. I've done them. I've done lots of FDCPA cases. All right, so this is our most technical slide to kind of understand the landscape of student loans. And this is important because you'll notice that we're using different CFR sections to control the regulations. So on the left-hand side, you see the Federal Family Education Loan Program, or FFEL. On the right side, you see the William P. Ford Federal Direct Loan Program, otherwise known as direct loans. Direct loans are just that. They are directly from the Department of Education, as opposed to FFEL, which, if you look at the third bullet, the originator is a bank or a guarantor. The bank is insured by the guarantor. The guarantor is insured by the Department of Education. Under the direct loan program, the loan is always with the Department of Education. There is no middleman. There's a servicer working for the Department of Education, but the loan is always held by the Department of Education. It never goes anywhere. So as an example, with the FFEL, I'm choosing names just for illustrative purposes. There's nothing behind it. Let's say the bank was Sallie Mae, was the originator. They were insured by ECMC. ECMC is insured by the Department of Education. So the way it works is very simple. You take the loan out from Sallie Mae disperses it. You go to school. If we screw up, if we default, Sallie Mae files an insurance claim called a default claim, and ECMC reimburses Sallie Mae. The note transfers to ECMC. Sallie Mae is now out of the picture forever on this particular loan. ECMC is now the creditor. They hold the note. They are not subject to the FDCPA under this particular issue. There's already case law in there. By the way, if you're looking to learn a lot more about this and want a foundation, National Consumer Law Center has a student loan law manual. It's where I started from, and I strongly suggest if you don't have it, go get it. So again, Sallie Mae would pass the loan to ECMC. ECMC would pay off Sallie Mae, and Sallie Mae is out. So now ECMC has the loan as the guarantee agency. They have all of the rights of remedy that the Department of Education would have, which we'll talk about in a second. ECMC has the loan, and if they have it for too long, which is undefined, they can file a default claim. They get paid by the Department of Education. They transfer the note to the Department of Education. ECMC is now out of the picture. Department of Education holds the loan. It is still an FFEL loan. It is still controlled by 34 CFR Section 682. It's just held by the Department of Education. Again, as opposed to a direct loan, which is always with the Department of Education and always subject to 34 CFR Section 685. Now, I will tell you, there is a lot of crossover between 682 and 685. They will say, they'll point to different sections because they're mostly redundant, but there are some small tweaks which I will attempt to point out so long as we have time. Now, you'll see on the bottom there, none of this applies to Perkins loans, and I'll talk about those when we get to the individual loans, which we're about to get to. So again, we have FFEL and we have direct loans. I want you to think about this kind of as Chrysler, Plymouth, Dodge. Plymouth and Dodge are the same cars. They just have different stickers on them. They're all made by Chrysler. All right. Types of federal student loans. We have Stafford loans, and that's the most popular one. These are if you're alive and breathing and going to a college, you can have a Stafford loan. They come in two kinds, subsidized and unsubsidized. Subsidized are need-based. It is the school that qualifies someone for subsidized for need-based. Nobody knows what the formulas are. The Department of Education tried to ascertain what those formulas are, and every school said, sorry, it's proprietary. The way it starts is borrower will fill out a FAFSA, the Federal Form for Free, it's the Federal Free Application for Student Aid, FAFSA, F-A-F-S-A. And it normalizes all the data, and then it goes to the school of the borrower's choice, and the schools process it through their formula, and that's why people get different student aid packages from different schools. Some schools have 100% need-based aid, which means they'll find a way to get that student the money they need to attend. Some of them don't, which means, sorry, if you can't afford it, don't come here, or get a private student loan. So that's key. Another key difference between a subsidized and an unsubsidized Stafford is during periods of deferment, including an in-school deferment, the government pays the interest. So as the government has now tagged the interest rates to the market and interest continues to go up, the government's paying the increase in the interest rate on subsidized loans while a borrower is in school or during any deferment periods, such as economic hardship deferment or an unemployment deferment. So that's the key difference between subsidized and unsubsidized. Then we have plus loans. Plus loans are loosely based on credit, and it's loosely based on credit. There are parent plus loans and graduate plus loans. The amount is based on the school's budget, which is called the cost of attendance. And the cost of attendance is not just tuition. It's tuition, room and board, or if they're off campus, it's a budget set aside for living off campus and eating. It includes textbooks. It includes health insurance, travel expenses to the school. Now think about this. If they go to UCF, because I don't want to pick between UF and FSU. If they go to UCF and they live in New York, their travel expenses is more than if they go to UCF and live in Palm Beach. So they have a higher budget for travel expenses. It also includes study abroad if they do that. If they're an older student, it can include child care. It can also include any monies needed for ADA compliance if there are disability needs, things of that sort. This is where the cost of attendance gets large. It's not just the tuition. And there are schools right now where their cost of attendance is upwards of $80,000 a year. If your jaw hasn't dropped, it means you've already seen this. And that's where plus loans can be much bigger than a Stafford loan. It's made to fill in the gap. Then we have Perkins loans. Perkins loans are originated by the school. They're paid to the school. They are administered by the school. So when Stafford and plus loans can be either an FFEL or a direct loan, again, the issue is who originated it. A Perkins loan is neither. A Perkins loan is originated by the school, paid to the school, administered by the school. So when you're seeing people being sued by a school, don't assume it's tuition. It could be a Perkins loan. This is very important when it comes to bankruptcy. Tuition is dischargeable in a bankruptcy. A Perkins loan is not because of 523A8AI. It is a federal student loan. It is non-dischargeable. Lastly, we have consolidation. Consolidations are wrapping up individual loans into one big loan. Again, credit doesn't matter because it's a federal student loan. So if you have a Stafford and you have a Plus, maybe you want to put them together. If you have a Perkins loan, you can put it together with your Stafford loans. This is usually done for one of three reasons. One, it's a way to get out of default. Two, it's a way to qualify for better payment plans. And three, it could be a way to convert an FFEL over to a direct loan so that you can qualify for public service loan forgiveness. I know I glossed over that. I'm going to get to that to the relevant section. Now you'll see a bullet here for spousal consolidation loans. Between 1998 and 2006, the government said, hey, if you get married, you can put your loans together with your spouse's loans because, you're happily married and you want to share your expenses and yada, yada, and it was the worst thing ever. So in 2006, married couples can no longer put their loans together. Unfortunately, when they killed the program, they didn't put an exit ramp in there. So people that have a spousal consolidation, if the happy ever after goes away and they become divorced, there's no way to split that spousal consolidation loan. There's no easy way to do it. If you have one of these and you have a difficulty, please contact me. I do have some outside-of-the-box ideas that have worked successfully, but there's not a huge percentage of these, so I don't want to waste a whole lot of time on it. I want to go back to Perkins loans real quick. The schools, if the loan defaults, the schools don't have the same remedies available that Department of Education or guarantee agencies have. Their only remedies are to hire a debt collector to call and attempt to collect or to sue. They don't have any administrative remedies. So that's very important to know. All right. So as an example, with Stafford loans, this is an example of the limits. Now, I know we became lawyers because we don't like math. I have an MBA, so I know how to use a calculator. As an example, the first year, the subsidized maximum they're allowed to have is $3,500. If they're a dependent, they can have at most $5,500. So if their subsidized maximum is $3,500, they can have an additional $2,000 unsubsidized, and for a total of $5,500. Now, what's the difference between dependent and independent? It has nothing to do with tax filing status. It has to do, and schools are very good at this, where does the student go when they're not at school? Do they go home? Who's paying for their car on campus? Who's paying for their health insurance? Who's sending them care packages, things of that sort? They are assumed to be a dependent if they are an undergraduate under the age of 22. They are assumed to be an independent if they're over the age of 22 or in a graduate program. So Doogie Howser, as an example, might have been considered an independent even though he was only 16 when he went to medical school. And if they're an independent, then they get an extra $4,000 a year for Stafford loans. Also, you will see in a minute Parent Plus loans. If a parent is denied a Parent Plus loan, then they can deem the student an independent to give them an extra $4,000. Now, I got to tell you, that doesn't do a whole lot for most of these people, but it's better than nothing. So again, most of our undergraduates are considered dependent. You can see the cumulative maximum for a Stafford loan is $31,000. And the average debt load for a newly minted undergraduate grad is about $28,000 or $29,000, which is first year, second year, third and fourth year, all added up. People tend to max these out because they can have it. So it's no coincidence that they're averaging $28,000 to $31,000. And they're not the problem clients, really, because even at $30,000, they get a minimum of 10 years to finance it. That's better than a car payment. No, the real problem are the graduate students. Let's say they decide to go to law school for some reason. They get $20,500 a year. So they come out of law school, if they finish in 3 years, owing $61,500. And then you add in their undergraduate of another $28,000. Now they've got nearly $90,000 just in Stafford loans. We haven't talked about the other loans. Now we have a problem. And these are the people that tend to be clients because it's just a wonder how they afford these loans. And you can see the maximum they're allowed to have is about $140,000. And so you're asking, well, how do they have loans that are higher than $140,000? Because I can tell you, I have clients that are upwards of $1 million or $500,000. And the reason is because of those plus loans. and I'll get to those plus loans in a minute, again, it's based on cost of attendance minus whatever financial aid they get. So the cost of attendance, again, includes tuition and fees, on-campus room and board or off-campus housing and food, books, supplies, transportation, loan origination fees, dependent care. Of course, the computer, we all get new computers as freshmen, and then new computers for law school, and then new computers if we got our LLM, all of these, any cost related to disability or eligible study abroad programs. So you can see these can be quite large. So with plus loans, again, it can be large. And I've seen people, parents can take out a plus loan for their undergraduate child, and it could be upwards of $40,000 a year. It takes them 4 years to graduate. That's $160,000 that the parent has. If they're a graduate, they can have graduate loans. So we talked about law students as an example. They've got, about $90,000 in Stafford's. Their plus loans could be another $40,000 a year at 160 plus the 90. That's where you're seeing federal loans tipping over $300,000 a year. It's insane, but it happens. So where do we start? We start at the website of the NSLDS. Now, if you're taking notes, get rid of the www. I forgot to edit the slide. They have since changed the website for security purposes. There's no www. It is simply nslds.ed.gov. And that NSLDS stands for the National Student Loan Data System, which is run by the Department of Education. It includes the date of origination and the amount of the loan, the current principal and interest rate at this current time, or if it's variable, it will say so. The current payment plan, it will tell you who the current lender, current servicer, and who the guarantee agency, but it will never list the debt collector. So if they're in default, you either contact the guarantee agency or the Department of Education and find out who's the debt collector. What I love about the NSLDS is this is much like a mini credit report. It gives a historical status of the loan. It includes the dates of repayment, when it defaulted, if there were any forbearances or deferments, things of that sort. So when your client says, I don't understand what happens, you can go through the NSLDS and say, okay, your loan was originated on this date, you started repayment on this date, you defaulted on this date, you got it out of default, you had a forbearance. You can literally run through the whole thing, and you can also see where did capitalization occur. Capitalization happens at the end of a forbearance, at the end of a deferment, upon defaulting, and upon curing from default. Capitalization, for those of you who don't know, it means we take the interest, we turn it into principal, which is why loans get bigger. And the interest grows at a quicker rate. This is where people say, but I only borrowed $5,000 and now they owe 15. Or they borrowed 50 and now owe 150. It's capitalization. That's really where it comes from. So we look at the NSLDS, and that's our starting point. So how do we get rid of these loans without a bankruptcy? It's administrative discharge. And you're familiar with some of these. So if the borrower dies, or if it's the student or a parent plus loan, you simply fill out the paperwork, include a copy of the death certificate, send it to the student loan servicer. Within 60 days, the loan is gone. Federal student loans die with the borrower or with the student if it's a parent plus loan. They do not affect the estate, period. There is a partial discharge for spousal consolidation. The spouse that passes, their portion of the loan is discharged. That is not one of my creative solutions to get rid of the spousal consolidation. Okay, the next one that many of you are familiar with is called the total and permanent disability. This is literally what it says. If your borrower is totally and permanently disabled, there are 3 ways to qualify. If they are a veteran that is 100% disabled from a service-related incident, you get a copy of that order, you staple it to the TPD application, total and permanent disability application, and within 60 days, that loan is gone forever. Not 90%, it's got to be 100% disability, service-related. The next 2 have a little bit more work to it. If they're on Social Security disability and their review period is 5 or more years, as reported on their BPQI, the benefit period query, it's 5 or more years, you staple a copy of the BPQI to the application, and within 60 days, that loan is gone. If you don't have the veteran or the SSDI, or if the SSDI shows a review period less than 5 years, then you have to use the doctor certification. which very simply the doctor runs through why the borrower can't work. And they've redone the form to make it very easy for a doctor to run through. It looks at both physical and it looks at mental. So a psychiatrist can also sign off on this if you have someone with a mental disability. They have to be an MD or a DO. If you have someone that is overseas, send them to an Army base or to a military base that has a U.S. doctor on it, and they can sign off on this. I do this all the time. If they receive approval for discharge through either the SSDI or the doctor certification, there is a 3-year monitoring period. And every year they will ask your borrower, have they made any money? If they haven't, they check the box that says no, and that's good for that year. If they have made any money, they have to verify it with a copy of the tax return. They are not allowed to make more than the poverty index for a family of 2, which I believe right now is a little over $16,000. That is earned income. Obviously, their SSDI doesn't count. They're talking about from work. So it is possible for them to work part-time.
Josh, can I interrupt with a couple questions that we've had come in?
Yes.
So one clarification. So for a veteran, it does need to be 100% disability?
Yes, it does.
Okay. And is there any relief for co-signers of private student loans, parents and friends who make the mistake of co-signing? Are they on the hook for the life of the loan?
They're on the hook for the life of the loan, although some private student loan lenders will offer a co-signer release if the borrower has been making payments for 12 to 24 months and the borrower passes a credit check. They're really hard to do, but I have seen them done.
Okay. And then one more. If somebody missed the deadline to renew an IDRP.
Oh, we're not there yet. We're not there yet.
Okay. All right. We'll hold that one off then.
Hold that one.
Thanks.
So this is total and permanent disability. So this is the story I love when a bankruptcy attorney calls me and says, yes, I filed an adversary proceeding to discharge their loan because they're in a wheelchair. And my response is, just file a total and permanent disability discharge and you're done in 60 days. You don't even need the bankruptcy. Okay. Other ways to discharge the loan through administrative discharge is a false certification. So this is school-based. The school certifies that the borrower is approved and eligible to attend the school. Well, if the student never graduated high school or never received a GED, or prior to 2012, there was an improper entrance exam. After 2012, no entrance exam. They must have a high school diploma or a GED. If they missed one of those, then they're not eligible to be at college. Then they're not eligible to have a federal student loan. So they fill out the paperwork, and within 60 days, the loan is gone. If the student could not meet state minimum job requirements, and this example actually comes out of Florida, where a blind man was admitted to a CDL driving school. Now, obviously, he can't meet the state minimum job requirements to hold the driver's license, so he can't be a truck driver. It's examples like that. Also, ID theft or fraud, and these are actually a little bit different. Fraud is if there was an unauthorized signature, or back in the day when we went to school, there were checks that we had to endorse. If we didn't endorse it, somebody else did. That would be fraud, as opposed to ID theft. ID theft is if your borrower has a judgment against a known person, and the judgment states that who the culprit is and that the culprit stole the borrower's identity for student loans. If you have that, you can send it to the Department of Education and get rid of the loan. ID theft is really hard to do because I don't know anyone that has such a judgment. So we go down to the fraud one. You'll have to show your borrower's signatures and exemplar signatures from around the time period of when the fraud happened. Obviously, this is more difficult with newer loans where there's a digital signature. If you have one of those, contact me offline, and I'm happy to tell you what we do with those. They're difficult, but we can work with them. The one that's also popular right now is closed school. If the school closed while the borrower was attending or within 120 days of the borrower withdrawing or dropping out, then you simply fill out that form, and within 60 days, the loan goes away. Now, my favorite is where they call and they say, my school just closed. I say, I'm sorry. They say, yeah, I graduated 6 years ago. My response is, well, then that doesn't matter. If they graduated the school and the school closes, it's irrelevant. They graduated, they have a degree. Now, they may not have use with that degree because of school reputation. That's different. That's in 2 bullets from now. But if they were attending the school when it closed and they didn't graduate, and the credits are non-transferable, which is usually for for-profit schools, they fill out the form, they get rid of their loan within 60 days. An unpaid refund, they've never really seen one of those, but we know about these. You'll remember about a month into our semesters is when all the good parties happened on campus. It's because we received a refund on some of our student loan, because you'll notice in cost of attendance, not all of that is direct payment. We don't pay the school for textbooks. We pay the bookstore. And so we received back some of that loan money to pay for some of those indirect expenses. That's an unpaid refund. If the borrower didn't get their refund, then that can be discharged. Again, I've never really seen one of those. The last one to talk about very quickly is the defense to repayment. This has become popular since the Corinthian debacle, and I know down in Florida these are very popular. These are schools like Wyotech and Heald and Corinthian schools. I know there was a bunch of them in Orlando, they're in Jacksonville, they're down in Miami. They're all over the place. If someone went to a school and they didn't receive what they were supposed to do, or they went to the school under duress or because of material misrepresentations, like the school lied about their placement rates or anything like that, they can fill out a defense to repayment form. It's a 15-page application, but they don't have to fill out all of it. They just have to find the right scenario that fits them, explain what the fraud was. Now, right now there's a backlog of 2 to 3 years on these, but it's not a bad idea to apply for them, because when you apply, any collection activity stops, including a wage garnishment. So again, if you think you have one of these, please feel free to contact me. I'm happy to give you a second opinion and send you on your way so you can help your client with these. But if they went to any of those Corinthian schools, there is a fast track, and those they'll get rid of within 60 days. Those are being processed. But there are other schools like the Art Institute, Cordon Bleu, things of those sort, where defense to repayment makes sense. So these are all administrative discharges, bankruptcy not. So now I want to get into repayment plans. And this is where the magic works. The first part is anyone who's taken out a loan expects intuitively to pay off the loan. That's how it works. You buy a car, you pay off the car. You buy a house, you pay off the house, or you sell it before you get to that point. But student loans are different. The first 4 programs are based on an amortization. There's the 10-year standard plan, which is you pay off the loan in 10 years. The graduated plan is a 10-year payment plan, but you start with the low payment, and every 2 years it steps up. There's the extended plan, which is 25 years at a fixed level, 25-year amortization. And then there's the extended graduated. If you have 25 years to pay it, it starts at a low payment, and every 2 years it increases. The extended graduated worked really well in the 80s and 90s when we would get a raise every 2 years, and we'd work for 25, so we'd pay off the loan. It hasn't worked in a really long time, because paying off $150,000 in 25 years, that's called a mortgage. So these are balance-based, but they don't work anymore. So let me give you some quick examples before I show you what else we do. So here, let's say their balance is $50,000. Their 10-year payment is almost $500, but if they do the 25-year, cuts in half to $250. If they do the graduated payment plan, it starts at $318, but if they do the extended graduated, the payment starts at just $140. Every 2 years, that would go up. And these are mostly affordable. But let's say they owe $150,000. Even on the 25-year plan, it starts at $750 a month. You got to be doing really well to pay $750 a month on your loan. Even at the most cost-effective, the extended graduated, it starts at $425. That's only for the first 2 years. After that, it's going to increase. So what is our solution? Income-driven repayment plans, IDR. This is the hub for the next 5 payment plans that are on this slide. The first one we talked about is income contingent repayment, ICR or ICRP. Again, you'll see these in a lot of adversary proceeding decisions, why people lose because they didn't apply for an income contingent repayment plan. This has been out since 1993 when direct loans came out. It's based on income and the loan balance. It's a 20% formula. There's an income-based repayment, IBR. This is based only on income. Then there's also pay, new IBR, and repay. This is the same as IBR, it's a better formula, it's 10%. Now I'm going to tell you what the formula is for IBR and the pay, new IBR, and repay. Very simple. You start with your borrower's AGI, adjusted gross income, as reported on their 1040. And if they file jointly, then yes, it's both of them. So you look at their AGI, you take out 150% of the poverty index for a family of their size. So if they're a family of 4, you take 150% of the poverty index for a family of 4. AGI minus poverty, 150% of poverty index equals discretionary income. You take either 15% of that for IDR or 10% of it for pay or repay or new IDR, and you divide that by 12, and that's their monthly payment. So I can tell you right now, with repay, if they're a single person working retail and only making about $20,000 a year, if they're making about $18,000 a year, with repay, their payment is zero. They're allowed to have a $0 payment. They're not in deferment, they're not in forbearance, they're on an IDR at $0. With these plans, every year you have to recertify. Somebody asked the question, I'm going to get to it in a second. And it's based on what your income is. So if your income goes up, your payment goes up. If income goes down, your payment goes down. If you're unemployed, you don't need a deferment. Guess what your payment is if you're unemployed? Well, your income is zero, so mathematically your payment is zero. And the reason we'd rather do that than have deferment is because you'll see that's last bullet, the balance of any loan remaining after 20 to 25 years is forgiven. On a deferment, it may not necessarily count towards the 20 or 25 years, but on a $0 payment, it does count. So if you have someone that just can't get on their feet for whatever reason, or if they have a large family, then they have a $0 payment, that's fine. I have clients paying $0 because they're retired and their Social Security is next to nothing. After 20 to 25 years, the balance is forgiven. The consequence right now, they get a 1099-C issued. There is potential for tax consequences, but this is where tax law comes in. Are they insolvent? What's their tax bracket? Is there a dispute maybe? We also hope that Congress will wake up in 25 years and make this non-taxable. Senator Durbin out of Illinois has been trying to do this since 2011, and he is slowly getting bipartisan support. And I think eventually there will be forgiveness, non-taxable. We'll see. You have to recertify every 12 months. It is possible to have a negative amortization. So yes, this loan will get bigger. And some people get frustrated with that. They say, well, my loan's getting bigger. Point them down to the fourth bullet. It doesn't matter. It's going to be forgiven. Somebody asked, what happens if you miss the deadline of the 12 months? It's month 13 and you haven't recertified. You can still recertify and get yourself back on that plan that you were on, whether it was IDR or repay or pay. You can still recertify. The problem is, if you miss the deadline, the interest capitalizes, so now you have a loan with higher principal. At the end of the day, it really doesn't matter because, again, after 20 to 25 years, it's forgiven anyway. Does it affect the 1099? This might be the wrong attitude, but who cares? You're kicking the can down the road 20 to 25 years, and I got to tell you, most of my clients are going to be retired by then. What's the tax consequence on a retired person? And then you get people that start at age 60. They say, well, I'm going to be dead before then. Great. You win because the loan dies with you. So, yes, you can recertify late. We try not to. All right. So as an example, here's the IDR payments. Repay would be cheaper. Now you'll see we look at total household income and the number in the household. We don't look at the balance of the loan. Let's say we have a household of two making $100,000. Their payment is $960. If only the wife owes, it's $960. If only the husband owes, it's $960. If they both have federal loans, their total payment combined is $960. They take that $960 and they split it pro rata based on who owes what. So if the husband owes 2 times more than the wife, 2/3 of the $960 goes to the husband's loan, and 1/3 of the $960 goes to the wife's loan. That's just how it works. So this way, married couple are not penalized if they both have loans. There's no double dip. It's split pro rata. And you can see that this really helps. And again, repay would be even cheaper than this. It wouldn't be $960. I believe repay would be more like $800. So that payment helps a lot. Real quick cheat sheet for you. These are all the payment plans: ICR, IDR, pay, new IDR, and repay. The term to forgiveness, 25 on IDR, 20 years under pay or new IDR. Repay is 20 or 25. And we go to footnote 1. If any of the loans under repay were for graduate levels, it's a 25-year forgiveness. If just undergraduate, it's only 20 years. The formula is 20% for ICR, 15% for IDR, and 10% for the rest. Direct loans can have any of these payment plans, but on the FFEL, IDR is the only plan available. So if they want repay on an FFEL, they consolidate over to direct loans. Now they can have repay. What if they have a Parent Plus loan? Now we have a problem. First of all, it has to be a direct loan, and we look at footnote 2. A Parent Plus loan, if it's inside of a direct consolidation loan, then it can have ICR, which has to be a direct loan. Now be careful here, because if you put all their loans together into a consolidation, the entire balance is stuck on ICR, which is 20%. So it's not always friendly, but it can still help the borrower. Can you ignore the spouse's AGI? Yes, except for repay. Here, if they file separately, you can avoid the spouse's income for ICR, IDR, pay, and new IDR. For repay, they're going to look at the spouse's income anyway, even if they file separately. So sometimes repay is not the best deal, but you have to run the numbers and decide. Now let's look at forgiveness plans. Public service loan forgiveness made the paper a year or two ago. They said, 99% of people were denied. They were denied mostly because they weren't on a qualifying payment plan. You need 3 things for public service loan forgiveness. Okay, you need 1, a qualifying employer, which is a government, federal, state, or local. It's got to be a U.S. one, a U.S. federal, or state, or local, or a nonprofit 501c3. Only a C3 qualifies. You have to be full-time W-2 worker, not just a volunteer. You've got to be W-2, full-time as defined by the employer, or 30 hours, whichever one is more. So if your employer says you have to be 34 hours a week to be full-time, then you've got to be 34 hours a week. If you have 2 part-time jobs that add up to 30 hours, let's say you're an adjunct professor at 2 different community colleges, if they add up to 30 hours a week on average, that still qualifies. Qualifying loans. Only direct loans qualify. If your borrower has an FFEL, consolidated over direct loans, now they qualify. The last thing they need, very important, they need to be on either the 10-year standard, which means they'll pay off the loan, or any of the IDRs we just talked about, ICR, IDR, pay, new IDR, or repay. Any of those. They have to do all 3 simultaneously. If they're missing any of these for any particular month, that one doesn't count. They need to do it for 120 months. It does not need to be consecutive. They can work for legal aid for 5 years, then go work privately, and then come back to legal aid. They start where they left off. Don't restart. The only thing that resets time for public service loan forgiveness is if you consolidate, because the accumulated time is on particular loans. When you consolidate, you have a new loan. So make sure you're set up and start, and that's it. If you think you need to consolidate in the future, you're going to restart your time. How do you apply for public service loan forgiveness? First of all, there's a form to certify that you have an eligible employer. You fill out the top, give it to HR, they fill out the rest to verify 1, they're a qualifying employer, and 2, the borrower is a full-time employee, W-2. And there is an actual application that you fill out after your 120th payment. That's why 99% of these people failed. This isn't a program that you have to sign up for. This is a program that you qualify for, and then you apply for it. It's like a rebate. You get the rebate after you buy the product. So here, after your 120 months, you file the public service loan application. You'll have to make payment 121 and 122 within 60 days. Department of Education will grant it. You'll actually get a refund for payment 121 and 122. They are granting these. I know people who have gotten it. So legal aid, you guys qualify. What I tell people to do is save stubs for proof of your payments, just in case there's a snafu. I haven't found a snafu yet. If you think you have a client with a snafu, contact me. I want that case. That's public service loan forgiveness. I talked about teacher loan forgiveness real quick. This is if they are a teacher. They get 17.5 forgiveness if they teach full-time for 5 consecutive years at an eligible school, and they teach math or science in high school or their special education at any grade level. If they're anything else, English or Spanish or art or music or science or social studies, they only get 5,000. Now, the 5 years that they count for the teacher loan forgiveness cannot be combined with public service loan forgiveness. So what I say is, if they're not math or science, you probably just want the public service loan forgiveness. Don't worry about it. If they owe $150,000, I don't even know that the 17.5 is worth it. That's for your client to decide. Most teachers will just go with public service loan forgiveness because most teachers are government employees. School boards are local government. Even if private schools, a lot of private schools are nonprofit. Religious schools count. Even clergy count. And for clergy, they have to have 30 hours a week on average of non-proselytizing. And I know a lot of clergy do a lot of outreach. They do a lot of public service, literally. So it's the time they're not on the pulpit that counts. Okay. If you have questions, again, contact me after. Happy to help with them. So let's talk about default and why we have people in our office. Okay. To default on a federal loan, you have to go 270 days late. Between day 1 and 270, you're not defaulted. You're delinquent. You can still save the loan. Compare this to a private loan. You breach after you miss one payment. Now, some promissory notes on private loans say it's at the discretion of the lender, but most of them say you miss a payment and you've defaulted, just like a credit card. For federal loans, you got to go 270 days late. You miss that ninth payment, you've defaulted. Consequences, you get collection calls. They are allowed to charge up to 25% collection fee. It's a contingent fee. They get 25% of whatever your borrower paid. So if your borrower sends $1, the first 25 cents goes to the debt collector, the other 75 cents goes to the loan. For a Perkins loan, they're allowed to charge 30% for the first assignment to a debt collector, 40% for every subsequent assignment to a debt collector or even a lawyer. So let's say they're being sued by a college on a Perkins loan for $10,000. That lawyer can charge an additional $4,000 for attorney's fees, so long as they billed for those $4,000. They still have to earn it, but they're allowed to get up to 40%, and that can be troublesome. Okay, other remedies. Federal tax refund intercept, where we see that normally from February through July, where people say, I didn't get my tax money, how do I get it back? It's really hard to get it back. If they can show that they're being evicted or they had dire circumstances, and this happened for actually a single mom of 3 in Florida. She was living in Section 8 housing, needed her air conditioning fixed. Apparently you guys in Florida need air conditioning. I don't need it here in Vermont. But it was something important, and it was for life quality, and she was able to get her refund back. But for most people, they're not going to get the refund back. The one that annoys me the most is Social Security offset. This includes SSDI, but not SSI, which is supplemental Social Security. But for disability or retirement Social Security, they can take up to 15% of it. They do need the borrower. You have to leave them with $750. Anything above that, they can touch. So you're taking money from people that don't have money to begin with. Wage garnishment, this is administrative. No lawsuit required. They give your borrower 30-day warning. If your borrower doesn't do anything, they can go right after those. This wage garnishment is administrative, so it takes precedence over a judicial garnishment. It ties with an IRS garnishment because it's still federal. There's only one thing that takes precedence over this administrative wage garnishment. If you guessed child support, you would be correct. Child support gets first dibs, and then it would be either an ED or an IRS garnishment. Which one goes first? Whichever one gets there first. So if ED gets there before the IRS has got to wait. The last one is a lawsuit. You'll see a lawsuit either from Department of Justice or from any of the guarantee agencies can hire outside counsel and can sue on those. And these will always be in federal district courts because it's a federal loan. How do you fix it? Okay, the first thing that people think they can do is, let's settle it. No, you can't settle it. The best they're going to do is give you a 10% discount, which is due within 90 days. Most people don't have that. If it's held by a guarantee agency, they can offer up to a 30% discount, but they'll never do that, not that I've seen, because if you don't settle, you got to get the loan out of default, and when you settle it, when you get the loan out of default, the guarantee agency gets 100%. So why would they give you a discount when they know they can get 100%? So what can you do? You can consolidate, which is again similar to a mortgage refinance, except credit's not a factor. It takes 30 to 90 days. You fill out the application, you mail it in. You get to choose your new servicer. There's one of 9. You can't do this if there's a garnishment or a judgment in place, and you can't do it if your only loan is a direct consolidation loan. So what do you do if there's a garnishment or a direct consolidation loan? Then you go to rehabilitation. Now, the advantage of rehabilitation, it takes the word default off the credit report. I don't know what that's worth, and I never sell it based on that. I think it's only worth 5 or 10 points. You have to make 9 monthly payments over 10 months, so you can skip a payment. Payments must be reasonable and affordable. The first shot they'll offer is a 15% formula. It's similar to IDR. It's the same number, but it's not IDR. You don't get forgiveness, any of that. So you ask for the 15% formula, so I give the client that only makes $20,000 a year, then they can have a payment that's $5 a month. The rehab payment must be $5 or more. So again, if they're low income, it's $5 a month. If they can't afford that 15% formula, maybe because of the wage garnishment, then you can ask for a financial review, which is based on mandatory expenses. Credit cards don't matter here, but housing and insurance and automobile and food and mandatory health care and things of that sort, that all goes into the financial review. And if it shows that it's a number less than 15%, then they can have it. But again, $5 is as low as you can go. You can only rehabilitate your loan once after 2008. Now, that's per loan. So let's say you had a Stafford loan and you rehabilitated it in 2010. That loan can't be rehabilitated again. But if it defaults, you can consolidate it. Now you have a direct consolidation loan. If that one defaults, you can still rehabilitate it because you've never done it before. Again, questions on the more intricacies, you're welcome to reach out to me. Deferments and forbearances, don't spend much time on this, but understand what your clients are talking about. Some deferments, you can have this until you default. When you're delinquent, you can have a deferment. When you're in school, that's automatic. For active military duty, they can have a deferment, economic hardship. But if they have an economic hardship, they can qualify for an IDR of 0, so they don't need it. If they're unemployed, their IDR is 0, so they don't need deferment. Forbearances come in discretionary or mandatory. Discretionary means the lender, the servicer will give it to you. You can have up to 36 months of discretionary income, and they'll usually give it because they can do it over the phone, as opposed to IDR requires paperwork. It still keeps them out of default, so the servicer is doing their job correctly. Bankruptcy options, very quickly. Number one, with 13 plans, you can enroll in an IDR through your Chapter 13 plan. There is approved language that is out there so that they can have 5 years of qualifying payments during a Chapter 13 that count either towards the 20 or 25-year forgiveness, or even better, they can knock out half of their public service loan forgiveness while they're in a Chapter 13. Why in the world wouldn't you do this? I do know that most of the Florida districts, if not all, are already moving to acceptance of this. I know the Middle District has got something big on the horizon, which is supposed to start very soon. This avoids the need for a discharge. It keeps the loan affordable. You don't even need an adversary. Because if the loan is affordable, then you're going to fail the first prong of runner anyway. There's no hardship when it's affordable. If your borrower's payment is 0, I think you're going to be hard-pressed to win an adversary. I'm not saying I agree with that argument, but let's look at the path of least resistance. It's $0. So you can get an affordable payment through the Chapter 13 plan. There is approved language that the Department of Education has signed off on. And so that's great. You can also cure default during a 13. You can either get approved rehabilitation or consolidation during a 13. And again, the bankruptcy stops a wage garnishment. So if the garnishment was stopping you from consolidation, you file a 13, now you can consolidate. So 13s are great tools for student loans. We haven't realized that before, but now they are. So really, how do we go through this? If it's a student loan, again, we look at bankruptcy. A private student loan may not be a student loan. Under 523A8B, they look at the IRS code. Was the education expense qualified? So look at cost of education. If the private loan was more than the cost of attendance, if it went above and beyond, it may not be a student loan. If the cosigner didn't have a dependent relationship with the signer, like grandma maybe, well, then it's not a student loan for grandma. And grandma, if she files a bankruptcy, is automatically discharged. It's not a bankruptcy. It's not a student loan under 523A8B on a private loan. So look at the details. It may not be a student loan at all to begin with. Here are some resources, nslds.ed.gov. Again, forget the www on that one. If they need a credit report, annualcreditreport.com. Studentaid.ed.gov has got lots of great information. Studentloanborrowerassistance.org is the NCLC website. And again, you're welcome to reach out to me. I'm happy to help. Do we have any questions?
We have quite a few questions, Josh, if you don't mind sticking around, and I'll try to get through these as quickly as we can.
Yep.
What if you've been paying for over 20 years, but only the last 10 have been IDR? Can it still be forgiven?
It can still be forgiven. If we're looking at public service loan forgiveness, then those 10 years might qualify. If we're looking at the regular 20 or 25-year IDR, then it's only those 10 years on IDR that count. So IDR forgiveness is only based on 20 to 25 years on IDR.
Okay. Can you switch to repay if you're already on IDR?
Yes, and you do it through the IDR application. On that application, you use that to enroll in IDR, to recertify an IDR, to recalculate your IDR if you've had a change in income, like if it went down. And the fourth one is you want to change, say, from IDR to repay. You can do that.
If someone switches plans, does their term restart?
No. The only thing that restarts it is if you do a consolidation and it's a brand new loan.
Okay. If a client was paying under ICR or IDR and is now paying under new IDR, will they get forgiven after 20 or 25 years?
We don't really know, but I believe it would switch to the 20-year.
Okay. For the situation with two spouses that owe student loans, do they both have to be on IDR plans for the pro rata repayment split to occur?
Yes.
If
they don't
you
have
qualify,
to be on the same IDR, but they don't have to be on the same IDR, but they both have to be on IDR for that pro rata split.
Okay. And if you qualified for a PSLF at one nonprofit and then subsequently switch jobs to a different qualifying nonprofit, do you have to update the form certifying the employer?
Yes. Yes, you do.
Okay. If you work for the state government and apply for PSLF a number of years ago and advised that the salary did not allow you to qualify because it was too high, even though it was under $60,000 at the time, is there a cutoff in salary that makes someone ineligible?
No, it's not the salary that makes you ineligible. It's that the salary in relation to your loan balance, you may not qualify for an income plan, an IDR. And so if you don't qualify for an IDR because you make more than what you owe, then you can't have public service loan forgiveness. And mathematically speaking, that checks because it means you're going to pay off the loan before 10 years happens anyway.
Okay. Is there a difference in forgiveness between IDR and repay?
No. IDR is a 25-year forgiveness. Repay would be 20 if you have only undergraduates, but if you have graduate levels, repay is also going to be 25 years.
Okay. Have you ever heard of payments being under review? I'm due for debt forgiveness, and they are reviewing 30 payments.
I see that happen with public service loan forgiveness. Fed Loan is the servicer that tracks that. And so I do see people asking them to verify that certain payments have counted. And so that's where I've seen reviews. I haven't seen the kind of review. If it's not that person asking the question, you're welcome to email me on that.
Okay. And then this is a comment that says when you switch plans, like from IDR to repay, your interest will capitalize. Is that true?
Yes, it will. It is true. What happens when you switch from IDR to any other plan, they actually capitalize your interest. You have to make 1 month of a regular payment, or you can ask for a forbearance payment of $5, and then they switch when you repay. The interest capitalizes, but again, if it's going to be forgiven, who cares, especially if it's public service loan forgiveness, not even taxable.
All right. I think that is all of our questions. Thank Josh. I think that those most questions we've ever had in a webinar, so I think you had a very engaged audience. And so we've now posted information for where you can join the public interest law section. And we've also got the course number to apply for CLE credit. We've also applied for judicial education credit, and that takes a little bit longer, so that one is still pending. If you want the PowerPoint that Josh used today, that's under handouts on the GoToMeeting panel. And we thank you all very much for your time and for your attendance today, and hopefully you found this helpful. Thanks again, Josh. We really appreciate it.
Thank you. Happy to help.